Hello and welcome to the latest legal update for the solicitors group TSG Legal TV residential property channel. My name is Paul Butt and today I will be discussing a few problems with regard to service charges in residential tenancies. The particular issues I'm going to be thinking about today are the kind of advice that we ought to be giving buyers of property or prospective buyers of property that we're acting for. Buyers of leasehold property, advice about the rights and obligations of landlords and tenants with regard to the payment of the service charge and the provision of the services. Arguably, I suppose you could say that this doesn't really become relevant to a buyer of a leasehold flat until problems arise. But unfortunately, the courts have shown in the past that when we're acting on a particular transaction and our retainer is limited to that transaction, i.e. in our case as conveyance as the purchase of this flat, if anything else comes to our notice during that transaction, which might be an issue for the client, then we are under an obligation to actually point that out to them. Not under an obligation to go into great detailed advice, lengthy advice that we can't or don't charge for, not suggesting that for a moment, but we are under an obligation just to point out that there are issues, and if they want further advice, then we would be prepared to give them that, obviously in return for an additional fee. So we're thinking of leasehold flats. The obvious things that we are going to be telling our purchaser are the issues with regard to the remaining term of the lease, the unexpired residue. I think we all know that once it gets down to sort of 60, 70 years, then they're going to have great difficulty mortgaging that property, great difficulty selling that property. I'm sure we all tell prospective clients whose leases are getting a little bit short that yes, it's okay at the moment, but when you come to sell, maybe you're going to have difficulties. Just a similar kind of thing I'm thinking of with regard to service charges. Lots of problems arise in flats with regard to service charges, disputes with landlords, disputes as to the services not being done correctly, disputes as to the amount that the landlord or the management company or managing agents is actually charging each individual flat tenant for the provision of the services. Just a mention, just a few words of what I'm suggesting about the rights that flat owners have in relation to such particular matters. So, as I say, this I think is clearly within our duty when we're acting on a purchase, not to go into great depth, but to mention the particular issues. So perhaps one thing we ought to mention is that there is legal provision that says that the services, when provided, must be provided to a reasonable standard, which can of course cover a multitude of sins, but it does give the flat owner the right to challenge services that aren't being provided to a reasonable standard. And equally, the costs that are being charged, the actual amount of the service charge being levied, has got to be of itself a reasonable amount. Again, I think we ought to be mentioning just that fact to them. And of course, it's fairly easy to do. We all give a standard pre-contract report to clients, setting out all the details of the work we've done in connection with the purchase. Very easy to have an extra page that simply covers the situation with regard to service charges. Once it's actually on your word processing system, on the standard form, very easy simply to include it. So it's not as though it's actually going to cost us anything extra to actually give this advice. And it might be beneficial in future. If problems do arise with the service charges, maybe the clients will now come back to us and instruct us with regard to those problems, because they will remember, hopefully, that they've read some guidance from us when they bought the property. They will know where to go. And looking at it at its blackest, it might save us from a negligence claim if we don't give that advice and clients then start claiming, well, had you told me this or you didn't told me that, I wouldn't have gone ahead with this transaction, I wouldn't have done this and it's all your fault, and please can I have some money off you. So as I say, it's very simple to do things like that. The other kind of protections that tenants have got are the consultation provisions. There's been a very recent case in the Court of Appeal, a very important case in the Court of Appeal, dealing with these consultation provisions and stressing how important they are. The Dajan Properties and Benson case, which makes it quite clear that if the landlord, managing agent or whatever misses out one of the stages in the consultation procedure, that might mean that the service charge payable in respect of what wasn't properly consulted isn't chargeable to the tenants. The management company will, of course, have incurred the expense in providing that service or whatever it was, but they will not be able to recover it. So very important from both the managing agent's, management company, landlord point of view to be well aware of the consultation provisions. Equally important from a tenant's point of view to know that in certain circumstances they've got to be consulted. And these consultation provisions, basically apply to major works that will involve each individual tenant in a payment of £250 or more, so it's got to be quite substantial, and long-term agreements entered into maybe for the provision of cleaning services, gardening services or whatever, where again the charge per tenant will be more than £100 per annum. Very, very complicated consultation provisions. Landlord, management company or whatever has got to explain to the tenants, using the prescribed forms, what they intend to do, and the tenants then have a right to respond to that, to agree or disagree, to make comments. In particular, they have a right to suggest people that the landlord might want to approach to get a quote for the provision of the work in question. And in certain circumstances, indeed, the landlord is obliged to try and obtain quotes from the people actually specified. And when the tenants have made their response, made their suggestions, the landlord's supposed to respond back again, saying what he thinks about it. Yes, I've read all your suggestions but don't agree, or whatever it might be. Detailed, complicated provisions which can drag on, can obviously be quite expensive from a landlord management company's point of view. But the, recent case law shows that if you miss out a meaningful part of that consultation procedure, you fail to respond to the tenant's initial suggestions, then that means that you haven't complied with those consultation regulations. It means that you will not be able to recover the costs incurred in relation to that matter. Obviously very significant from the point of view of a private landlord, a property company landlord. What the case shows as well, though, is that maybe there would be a slightly different approach from the courts if the landlord was a tenants management company. The persons providing the services were a tenants management company. Because obviously in that case it's the tenants owning the company and they're the ones that will have to foot the bill for the management company not having carried out the consultation properly. But certainly in the case of a property company responsible for the repairs, very serious consequences if the particular provisions are not complied with. As I understand it, that particular Dajan case is actually being referred to the Supreme Court for them to have a look at. Shows how important that Dajan are actually taking that particular decision from their point of view. So just a thought then of a few things that perhaps we ought to be mentioning to people buying flats, particularly people who have never owned a flat before, don't even know what the service charge is there for, about the rights and obligations that they might be entering into. So just a few thoughts on that. Well, on behalf of myself and the Solicitors Group, I would thank you for listening to this legal update. Keep an eye out for further updates from TSG Legal TV, and we look forward to seeing you again soon.